Good morning, everyone. We are bound to the next topic on the general provisions with regard to the contract, Article 1318 to 1346. So we will be dealing on Chapter 18, the essential requisites of contracts. We are done with obligations and we are now in the contracts because these are the two important subjects in obligations and contracts. We have learned already what is the concept of contracts. Now we are going to discuss the essential requisites of contracts. There is no contract unless the following requisites concur. First, consent of the contracting parties. Second, object certain, which is the subject matter of the contract. And third, cause of the obligation, which is established. These are the important elements of the contract. No, kung ni isa dito sa mga requisites na ito ay hindi present, then the contract is void, as if there is no contract. And we will discuss one by one yung mga essential requisites ng contract na ito. The first requisite is consent. It provides in Article 1319 that consent is manifested by the making of the offer and the acceptance upon the thing and the cause which are to constitute the contract. The offer must be certain and the acceptance absolute. The object of the offer must be certain and the acceptance is absolute. So if you're going to offer a rocks coming from the moon, then it is not a certain offer. And the acceptance must be absolute, that they are going to accept the offer. If you're going to give a car, then there must be an acceptance. Otherwise, if there is a condition na hindi ko i-accept ang car na yan kung hindi ka magbabayad sa akin ng ganito at ganito. So it should be absolute. It should be yes, walang mga qualifying circumstances. And a qualified acceptance constitutes a counteroffer. So kung may mga conditions, kaya ang sabi ko kanina, so it will constitute a counteroffer. For example, si A magbibigay ng car, and then sabi ni B na, I will just accept the car if you're going to give me 100,000 pesos. So that is a qualified acceptance. Anong ibig sabihin yan? Ang tawag niyan is a counter-offer. Acceptance made by letter or telegram does not bind the offerer except from the time it came to his knowledge. The contract in such a case is presumed to have been entered into the place where the offer was made. Before, since there was no Facebook and Messenger, they rely only to letter or telegram. Kung hindi makarating kay offerer yung acceptance na, okay, I will accept your offer, then the acceptance does not bind the offerer kung hindi pa niya alam. So, si offerer, pwede niyang i-offer sa iba yung kanyang offer na amount of car, no, na ibebenta niyang car in this particular amount. So, kung hindi mag-accept si offeree, so ibig sabihin si offerer ay pwede niya ibenta sa iba. Okay? Concept of consent. The most important element which constitutes the very heart and soul of contract is unquestionably the consent of contracting parties. In its derivative sense, the word consent merely means the agreement of wills. That is the, kasi maraming kaso when it comes to consent. And this is one of the most important important elements, no, sa isang contract. Dapat there should be a consent coming from the both parties. Consequently, as applied to contracts, it may be defined as the concurrence of the wills of the contracting parties with respect to the object and the cause which shall constitute the contract. And though there are essential requisites of contract, there is also requisites of consent. Under the Civil Code, in order that there is consent, the following requisite must concur. So first, the consent must be manifested by the concurrence of the offer and the acceptance. That is in Articles 1319 to 1326. No? And second, the contracting parties must possess the necessary legal capacity. So that will be discussed sa Articles 1327 to 1327. Ibig sabihin, if there is no legal capacity, like for instance, minor, no, nag-execute ng contract, now it will not bind the party, as if there is no consent because, again, the minors cannot give consent. Kung mag-contract ka sa minor, like 13 years old, then as if there is no consent. So you have to take note on that. In order the consent no, will concur, there should be a necessary legal capacity on the both parties. And third, the consent must be intelligent, free, spontaneous, and real. So the first is expressly stated in the code, and the second and third are the implied one. Now, kailan ba naging perfect ang isang contract? As a general rule, contracts are perfected from the moment that there is a manifestation of the concurrence between the offer and the acceptance with respect to the object and the cause which shall constitute the contract. Kasi kung merong consent na kaagad, kasali na doon yung object at saka yung cause or the consideration of the said contract. Now, if mag-agree kayo sa price, if mag-agree kayo sa object na i-deliver, then perhaps that would came birth to a perfected contract. But however, there are also qualifications. If the acceptance made by letter or telegram, you must distinguish. And this, according to this article in 1319 of paragraph 2, the contract is perfected from the moment that the offerer has knowledge of such acceptance. Well, according to Article 54 of the Code of Commerce, now if you are going to scrutinize the Code of Commerce, the contract is perfected from the moment an answer is made accepting the offer. Because of the repealing clause found in Article 2070 of the new Civil Code, it is submitted that Article 54 of the Code of Commerce can now be applied only to purely commercial contracts, such as joint accounts, maritime contracts, and etc. So therefore, we can say that the rule found in second paragraph of Article 1319 of the new Civil Code is the general rule, while that found in Article 54 of the Code of Commerce is the exception. So you have to take note on that. Ibig sabihin, yung Article 54 of the Code of Commerce and then yung Article 1319, hindi sila nagko-conflict. Ibig sabihin, they are different. There is different interpretation. So, ang Article 1319 is a general rule and ang Article 54 is the exception to the general rule. Manifestation of consent. Before there is consent, it is essential that it must be manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Once there is such a manifestation of the concurrence of the wills of the contracting parties, the period or stage of negotiation is terminated. So the contract, if consensual, is finally perfected na. So ibig sabihin, if the contract is already perfected, wala nang negotiation na mangyayari. Because ang negotiation, no, mag-negotiate pa kayo sa price, kung magkano, kung saan i-deliver. So, if you already agree on that particular sense, at na perfect na ang contract, wala nang negotiation na mangyayari. Unless otherwise, you're going to repeal the contract or you're going to rescind the contract. Now, in the case of Ramon Magsaysay Award Foundation versus Court of Appeals, no, it was promulgated on January 17, 1985. It was held that even if the draft renewal contract had not been signed by the lessor, the parties may be deemed to have agreed to review their lease contract considering the exchanges of letters between and the implementing acts of the parties. So technically, if there is already exchanges of letters, no, between the lessor and the lessee, and the renewal of the contract, no, yung draft ng renewal of contract is only for purposes of um, a legal binding. No, it is considered that there is already that they have agreed to the different terms and conditions of the lease contract. Article 1321, the person making the offer may fix the time, place, and manner of acceptance, all of which must be complied with. Okay, may nakalimutan pala ako sa Article 1320. An acceptance may be expressed or implied. So it may be in a form of writing, or it may be in a form of oral or verbal, no, acceptance. So technically, in Article 1321, no, the offer must be communicated and received by the offeree. It may be by letter, telephone, email, or the like. It may be expressed or implied by the language or acts of the offerer understood as such by the other party. Example, B attended an auction sale on particular pawn shop. When the auctioneer asked for a bid at certain price of an antique furniture, B nodded, no, ninad siya, after getting the auctioneer's attention. The nod by B constitutes an implied offer. It was a sufficient communication to the auctioneer of B's intention to make a valid offer. So you have to take note, no? By simply nodding will constitute a valid offer because according to Article 1320, the acceptance may be expressed or implied. Article 1322, an offer made through an agent is accepted from the time acceptance is communicated to him. So if the offer made or meron kang agent, no? So there would be no meeting of the minds, no, if the principal himself made the offer and the acceptance is communicated to the agent, unless, of course, the latter is authorized to receive the acceptance. So if it is not properly communicated to the principal, yung offeror talaga, because you have the agent, then it will not bind, no, both the offeree and the offeror. And of course, but if there is a express stipulation, may dala siyang resolution ako, anong conditions o kahit anong mga offers or mga acceptance na gagawin ng agent is valid and binding with the use of that resolution and express stipulation. 1323, an offer becomes ineffective upon the death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. Technically, even if the offer is not withdrawn, its acceptance will not produce a meeting of the minds in case the offer has already become ineffective because of the death, civil interdiction, insanity, or insolvency of either party before the conveyance of the acceptance of the offer. Article 1324, when the offer has allowed the offeree a certain period to accept, the offer may be withdrawn at any time before acceptance by communicating such withdrawal, except when the option is founded upon a consideration, something paid or promise. Technically, there are three concepts here in Article 1324, we have the option contract, option period, and the option money. When I talk about option contract, it is one giving a person for a consideration a certain period within which to accept the offer of the offerer. It is separate and distinct from the contract, which will be perfected upon the acceptance of the offer. Technically, this option contract is a security no, na ibibigay ng ating mga offeree. Na ibibigay sa offering by the offerer. Kung halimbawa, I will give you 1 year. Now, this is an option contract to buy my property, provided that you will pay me 10,000 pesos for that 1 year, no, na hindi ko bebenta yung aking ari-arian. Technically, during that year, because there is an option contract, hindi maibibenta ni offeror yung kanyang ari-arian. Of course, if you're going to pay 10,000 pesos as a security of that particular contract. Kasi you've give a ample time to the offeree to think no, whether he will purchase the said property. That is an option contract. An option period is the period given within which the offeree must accept the offer. It will be stipulated in the contract as well. Option money is the money paid or promised to be paid in consideration for the option. So again, there would be, even though there would be no option contract no, without consideration, without paying such. Pero meron din mga option contract na walang consideration. And as a general rule, meron talagang option money na ibibigay to really affect the option contract. Article 1325, unless it appears otherwise, business advertisements of things for sale are not definite offers, but mere invitations to make an offer. So technically, if halimbawa ay nag-advertise siya ng sabon at ikaw ay puputi, it is not a definite offers. Kung hindi ka puputi, you could not sue them. Bakit hindi ako pumuti sa sabon na binibenta mo? So you cannot sue them, you cannot file a case against them because that is only a mere invitations to make an offer. For examples, for sale of 200 square meters lot at Green Plains Village in Quezon City for 1 million pesos. Tapos merong telephone number doon na 844-1284. This is not a definite offer. Another example, for sale of 200 square meters lot at Green Plains Village, Quezon City, located at the corner of Jeronimo and Magallanes Street for 1 million pesos cash. Telephone number 844-1284. So technically, this is a definite offer. Ito yung definite offer. Merong word na cash. Article 1326, advertisements for bidders are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder unless the contrary appears. In a certain mga government agencies, there is also a mga bidding systems of bidding process. And lahat ng mga companies, like mga construction companies, if there is a certain building na itatayo doon sa mga eskwelahan, they will invite all the construction firms no, to bid kung sino yung pinaka maganda na quality ng mga gawa ng mga construction, gawa ng mga buildings. Then the government will choose among all those bidders. And of course, yung medyo hindi ka mahalan. But it doesn't mean na ikaw yung pinakamababa, you will get the project. No, it depends upon the quality of your construction firm or quality of your building. Article 1327, the following cannot give consent to a contract. So, ibig sabihin, ito yung mga persons na hindi makapagbigay ng consent to a contract. First one, the unemancipated minors. When we talk about unemancipated minors, they refer to those persons who have not yet reached the age of majority, and in the Philippines that is 18 years old, and are still subject to parental authority. A minor can be emancipated by attainment of the age of majority, by marriage, or by the concession recorded in the civil register of the father or of the mother who exercise parental authority. Number 2, insane or demented persons and deaf mutes who do not know how to write. An insane or demented person talks about the insanity. The insanity must exist at the time of contracting, unless proved otherwise. A person is presumed sane. So technically, if you are going to contract a certain terms and agreement, and then during that time you are sane or okay lang yung ano mo, you are not insane during that time. And then eventually, after you contracted the contracts, after the perfection of the contract, naging insane ka na. So the reckoning period in order to validate a contract is yung kailan kayo nag-execute ng contract. And the execution of contract, since you are still not insane during that time, then that is a valid contract and you can give consent. Deaf mutes, they are persons who are deaf and dumb. No, and deaf mutes knows how to write, the contract is valid if he know how to write. If he knows how to write, then he is capable of giving intelligent consent. And a person who does not know how to write, does not know how to read, and one who knows how to read necessarily knows how to write. A contract entered into by deaf mute who knows how to read is therefore valid, although he cannot write because of some physical reasons. Okay? Article 1328. Contracts entered into during a lucid interval are valid. Yung sinabi ko kanina, if you're in a lucid interval or okay ang imuhang yung mga panghuna-huna nimo, then that is a valid interval. I mean, that is valid contract during the lucid interval. Contracts agreed to in a state of drunkenness or during a hypnotic spell are voidable. If you are drunk during that time, parte ni mo hubuga, and you execute a contract, that is not totally void, but that is voidable. Ibig sabihin, it will be void until annulled. So there is a complaint na hubog man siya during the execution of the contract. If there is no complaint, magpabili ng enforceable ang contract and it will become still valid. Even if party ni mo hubuga during that time of the execution of the contract. But if there is an annulment complaint against the contract, then it will become void. Article 1329, the incapacity declared in Article 1327 is subject to the modification determined by law and is understood to be without prejudice to special disqualifications established in the laws. Article 1330. 1330, a contract where consent is given through mistake, violence, intimidation to influence, or fraud is voidable. So, ibig sabihin, hindi siya totally void, no? Outright void. But if there is a complaint that the said contract is through a mistake, violence, intimidation, and to influence, then it's up to the court to declare whether the contract is void or not. 1331, In order that the mistake may invalidate consent, it should refer to the substance of the thing which is the object of the contract, or to those conditions which have principally moved one or both parties to enter into the contract. Mistake as to identity or qualifications of one of the parties will vitiate consent only when such identity or qualifications have been the principal cause of the contract. Third paragraph, a simple mistake of account shall give rise to its correction in 1331. You have to put a stars on 1331 because this is one of the most important provisions of the Civil Code. When we talk about mistake or error, it is a false notion of a thing or a fact material to the contract. And how about the nature of mistake? Mistake may be of fact or of law in general. And then mistake contemplated by law, a substantial mistake of fact. So that is, the party would not have given his consent had he known of the mistake. Hence, not every mistake will vitiate consent and make a contract voidable. And the mistake may be unilateral, when only one party is mistaken about a material fact, or bilateral, when both parties are in error. So you have to take note on that. Article 1332, when one of the parties is unable to read, or if the contract is in a language not understood by him, and mistake or fraud is alleged, the person enforcing the contract must show that the terms thereof have been fully explained to the former. So technically, when a person signs a document, the presumption is that he does so with full knowledge and understanding of the contents of the same. So therefore, he or she is bound by all the contents. Kung nag-sign ka talaga sa contract, ibig sabihin, alam mo kung ano ang nasa loob ng contract. That is a presumption of the law. And should he later on allege fraud or mistake, it is incumbent upon him to prove his allegation. Kung halimbawang there is mistake or fraud, you have to prove that you are there is a concealment and there is a fraud. When they let me sign that kind of contract na nadali ako, no? You have to prove that one. Otherwise, the contract is still enforceable. Article 1333, there is no mistake if the party alleging it knew the doubt, contingency, or risk affecting the object of the contract. If a party knew beforehand the doubt, or contingency, or risk affecting the object of the contract, it is to be assumed that he was willing to take chances and cannot therefore claim mistake kung alam naman niya na there is a already doubt, no, contingency, or risk affecting the object of the contract. For example, si Juan bought a parcel of land from Pedro, who informed him before the contract was perfected that the land was involved in a litigation in which De La Cruz is the claimant. No? In case the land is recovered later on by De La Cruz, Juan cannot allege mistake in his contract because he knew the risk that the land might later on be recovered by De La Cruz. So alam naman niya na yung subject na land is there is a claimant in litigation, which is si De La Cruz. No? Later on, he could not raise that claim that there is a mistake because alam na alam niya kung ano ang encumbrance on that particular land. Article 1334, mutual error as to the legal effect of an agreement when the real purpose of the party is frustrated may vitiate consent. So as a rule, mistake of law does not invalidate consent because Ignorance of the law excuses no one from compliance therewith. That is according to Article 3. And when mistake of law vitiates consent, kailan pala naging ma-vitiate yung consent mo when there is mistake of law? Does not generally vitiate, the mistake of law does not generally vitiate consent as a general rule. But when there is a mistake on a doubtful question of law or on the construction or application of law, this is analogous to a mistake of fact. And the maxim here is ignorantia legis neminem excusat, or ignorance of the law excuses no one, should have no proper application in this particular case. When even the highest courts are sometimes divided upon difficult legal questions, and when one half of the lawyers in all controversies on a legal question are wrong, why should a layman be held accountable for this honest mistake on a doubtful legal issue? If the issue is debatable, then technically, no, if there is a doubt when it comes to this particular issue or this particular law, no, sa mga lawyers, no, how much more sa mga ordinary people. Article 1335, there is violence when, in order to wrest consent, serious or irresistible force is employed. There is intimidation when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property, or upon person or property of his spouse, descendants, or ascendants, to give his consent. So you have to distinguish the violence and the intimidation. To determine the degree of intimidation, the age, sex, and condition of the person shall be borne in mind. And the threat to enforce one's claim through competent authority, if the claim is just or legal, does not vitiate consent. And the nature of intimidation or threat under the above article, for intimidation to vitiate consent of a party to a contract, the following requisites must be present. First, it must produce a reasonable and well-grounded fear of an evil. Second, the evil must be imminent and grave. Third, the evil must be upon his person or property, or that of his spouse, descendants, or ascendants. And fourth, it is the reason why he enters into the contract. Okay. Article 1336, violence or intimidation shall annul the obligation, although it may have been employed by a third person who did not take part in the contract. Article 1337, there is undue influence when a person takes improper advantage of his power over the will of another, depriving the latter of a reasonable freedom of choice. The following circumstances shall be considered: the confidential, family, spiritual, and other relations between the parties, or the fact that the person alleged to have been unduly influenced by suffering from mental weakness, or was ignorant or in financial distress. Example, X, a tenant, is in a need of 10,000 pesos, no, to pay his landlord, who is seeking to eject him for failure to pay the rents. X tries to borrow from Y, but the latter instead tells him to sell his piano for 10,000. Si X has nobody to turn to for assistance. If X does not want to sell the piano, but he is compelled to sell it because of his financial condition, the sale may be avoided on the ground of undue influence. No? Agreements between the lender and the borrower are closely scrutinized because they are not always at arm's length. That is the perspective. 1338, there is fraud when through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which without them he would not have agreed to. And there are the fraud being mentioned here is the causal fraud. And to talk about causal fraud, it is a fraud committed by one party before or at the time of the celebration of the contract to secure the consent of the other. It is fraud. It is the fraud used by party to induce the other to enter into a contract without which the latter would not have agreed to. The fraud contemplated in this article is causal fraud and must be distinguished from the fraud dealt with in Article 1170. 1339. Failure to disclose facts when there is a duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. Example, CS sold to be stocks traded in the stock exchange at a certain price. No? S believed that the price of stocks would go down, and it did. The sale is valid because S was not bound to make disclosure of his reasons for his belief. Because again, in the stocks exchange, talagang nagtataas at bumababa ang mga price. Article 1340, the usual exaggerations in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. To constitute fraud, here, the misrepresentation must refer to facts, not opinions. Ordinarily, a mere expression of an opinion does not signify fraud. In order that it may amount to fraud, the following requisite must be present. First, it must be made by an expert. Second, the other contracting party has relied on the expert's opinion. Third, the opinion turned out to be false or erroneous. So those are the requisites. Example, yung magbebenta ng sabon. And his opinion, yung sabon na ibinibenta niya is talagang puputi ka. No? Kahit yung mga singit-singitan mo, talagang puputi. That is his or her opinion. But it will not constitute fraud because that is only his opinion. But when we talk about kung halimbawa siya ay si Vicky Bello, no? Tapos sasabihin ni Vicky Bello na talagang sabon na ito ay there is a certain ingredient na talagang puputi ka. So since Vicky Bello is a expert and technically hindi pala puputi, no, yung mga yung mga kliyente, then there is fraud because the one making the statement is an expert. That is one of the requisites. 1341. Misrepresentation by a third person does not vitiate consent unless such misrepresentation has created substantial mistake, and the same is mutual. 1342. Misrepresentation by a third person does not vitiate consent unless such misrepresentation has created substantial mistake, and the same is mutual as 1342. 1343. Misrepresentation made in good faith is not fraudulent but may constitute error. Example, S sold a ring to B, and CS honestly believed that what he sold to B was a diamond ring. It turned out that it was not a diamond ring. So the misrepresentation of B is a mere mistake, and the contract is voidable on that ground and not on the ground of fraud. Because of mistake, no? And S is in good faith, no, hindi niya talaga alam na yung nasold pala niya is not a diamond ring. So the contract is voidable. It could be annulled. 1344. In order that the fraud may make a contract voidable, it should be serious and it should not have been employed by contracting parties. And there is 1344. So 1344, meron tayong incidental fraud only oblige the persons employing it to pay damages. That is in 1344. because there are two kinds of fraud in the making of the contract: the causal fraud and the incidental fraud. When we talk about causal fraud, which is a ground for the annulment of a contract, although it may also give rise to an action for damages. And when we talk about incidental fraud, which only renders the party who employs it liable for damages because the fraud was not the principal inducement that led the other to give his consent. And this kind of fraud must not be confused with the fraud in Articles 1170 and 1171 if you are going to um, review those articles, which refers to that occurring in the performance of a contract without affecting its validity. Both kinds of incidental fraud do not vitiate consent. Okay, and then Article 1345, simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all. The latter, when the parties conceal their true agreement. We talk about conceal, ilang gitago ang ilahang true agreement, no, on a certain contract. 1346, an absolutely simulated or fictitious contract is void. A relative simulation, it does not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to their real agreement. We talk about simulation of a contract, it is an act of deliberately deceiving others, no? Imo siyang maruan, uh, oh, naghatag og mga unnecessary na mga remarks, which is para ma-deceive lang siya, para ma-influence siya when it comes to signing the contract. By feigning or pretending by agreement, the appearance of a contract which is either non-existent or concealed. And there are kinds of simulation. There are absolute simulation and relative simulation. When we talk about absolute simulation, when the contract does not really exist and the parties do not intend to be bound at all. Absolutely simulated or fictitious contracts are inexistent and void. Example, D is indebted to C. Upon learning that C is going to enforce his credit, D pretended to sell his land to B, his father-in-law. And D did not receive a single centavo for the transaction, and he continued in possession of the land as the contract was merely simulated or fictitious. So there is no contract of sale in this case, as the parties do not intend to be bound at all. Because because para hindi makuha ni C, no, yung kanyang ari-arian, dahil yung contract pala is para i-enforce yung credit, kunin yung instead of hindi kasi hindi makabayad na si D, si C kukunin na lang yung lupa, no, ni D. So para hindi makuha yung lupa, binenta niya kunuhay sa kanyang father-in-law yung lupa, but actually wala siyang na-receive any amount. And since the intention of the contract is para i-conceal lang, para itago yung ari-arian, so technically there is no contract of sale in that particular case between kay B na kanyang father-in-law and kay D. So technically, this contract is simulated, and that is an absolute simulation. We have also relative simulation. When the contract entered into by the parties is different from their true agreement, the parties are bound by their real agreement provided it does not prejudice a third person, is not intended for a purpose contrary to law, morals, good customs, public order, or public policy. If they are contracting, kung si A at saka si B, yung contract pala nila is to pay the amount of 10,000 pesos for a period of 2 years. Pero ang nakalagay sa contract is 20,000 pesos for a period of 1 year. But the real agreement, yung naagrihan nila is only 10,000 pesos for 2 years. So doon tayo sa true agreement nila, which is the 10,000 pesos per month for 2 years. Kahit ang nakalagay is 20,000 pesos per month for 1 year. So doon tayo papasok sa true agreement nila. Provided na walang ma-prejudice ng mga third party. Okay? So that is from Articles 1318 to 1346. Now, to check whether you are listening to my lectures, you have to answer page on your book on page 300, the study guide, 369 to 370. So merong mga problems dyan. Now we have problems in the third part, problems. Explain or state briefly the rule or reason for your answer. We have 5 questions, no? 1, 2, 3, 4, 5 questions. Dito sa page 369 to 370. You have to choose only one question and then answer it briefly and concisely. Tomorrow's the deadline. I mean, yes, tomorrow morning is the deadline. And then you are going to post it to our GC. So yung first 5 na makapag-posts ng kanilang mga answer, whether it is wrong or not, will have a corresponding gifts, no, na ma-receive on tomorrow evening sa ating klase. So again, first 5, you have only to choose one from among the 5 questions sa study guide sa 369 to 370. And then later on, I will check also that one because that would be an additional points to your mga gagmay na mga exams on the final term exams. Okay, perhaps that would be all. And thank you for listening.